Yeah, my name is Bill Schwartz. I'm the pro bono coordinator for the Northwest Immigrant Rights Project here in Tacoma. And basically my role is to work with recruiting, training, and mentoring volunteer attorneys to take cases at the detention center and work with clients in detention. So today, I think hopefully everyone saw the advertisement for what we'll be doing today. Our first presentation, we're going to basically go over immigration law in really big, broad strokes and basically, kind of make it clear that this is really, really complicated stuff and kind of give you an idea of all of the different routes and avenues of it just to create a framework. And then after that, we're going to have a little break. We're going to do a second session where we dig right into asylum law in particular, and my colleague Jesse Reams is going to be leading that. And then afterwards, we're going to talk specifically about working with folks in detention and the specific challenges and nuances that come with that, and some experiences that Jesse and I have had to inform us and kind of help us to be better advocates for people in detention and kind of pass that forward for you all as you might be taking cases in the future. So without further ado, we'll get started. So a quick basic overview of the immigration system. One thing that makes immigration really complicated, as you'll see, is that it's not in a central part of the government. There's not a Department of Immigration. Immigration practice and law is divided between three different government departments. There's the Department of Homeland Security, which handles citizenship and immigration services, applications for green cards, things of that nature here within the United States boundaries. We have ICE enforcement and Customs and Border Protection. Then also immigration law is covered in the Department of Justice under the Attorney General, the Executive Office for Immigration Review, which is the immigration court system, the Board of Immigration Appeals, and then finally there's the Department of State, which handles any immigration work that happens at departments or embassies and consulates abroad. Another thing that's interesting about immigration law is that there's many different sources of law. So there's not one handy book that you can look to that's going to teach you all of immigration law. Immigration law is covered in part in the Constitution and various statutes, in particular the Immigration and Nationality Act, which is probably the most comprehensive immigration law. A bunch of regulations, and again, because there are different departments, there's the Department of Homeland Security is covered under the Code of Federal Regulations at 8 CFR Section 101. Thus, anything with the Attorney General and the Department of the Executive Office of Immigration Review, immigration courts, also in the Code of Federal Regulations in that chapter, and then the Department of State is all at 22 CFR. Another thing that really affects immigration law and something that we're very aware of here in the Ninth Circuit is case law, which is very relevant and can change depending on where your client lives in the United States. And then there's other agency materials that you'll see, memos that are released by ICE directors, things of that nature. The Foreign Affairs Manual provides guidance on Department of State cases. So basically there's a wide array of places where you can find the answer to your question, and almost as important as knowing the answer is knowing where to look to get started. And again, they say you shouldn't put little font on a slide, but this is just a list of some different types of immigration status. So when people talk about immigration status as an understanding what they mean, there's a whole bunch of different ways to get lawful status, and they can be very complicated and nuanced. So there's definitely a lot of reasons to do your homework and research up on this before you try to practice immigration law. The main things to know, though, is that everything can be divided up into citizens and non-citizens. So there are a few different ways that you can become a citizen, either by being born here in the United States, applying for naturalization if you were a lawful permanent resident, or acquiring it or deriving it through a relation to a parent while you were a young child. And then otherwise, there are non-citizens who fall into three general categories. The most common are lawful permanent residents, green card holders, and you're going to see the abbreviation LPR all over today. Immigration lawyers really, really like acronyms and word salad, alphabet soup kind of stuff, so you're going to see a lot of that, and LPR is going to be one of the very common ones you'll see. just because it's nice shorthand. In addition to lawful permanent residents, there are asylees and refugees who are not necessarily permanent residents but have a permanent status. And then there are people with temporary legal status, so people on student visas, temporary workers, visitors, tourists, and people who have other kinds of temporary visas. And then the final category of non-citizens are people who are undocumented, so people who had a visa that had expired, they entered without permission into the United States. And then obviously a big question, the ultimate goal of a lot of immigration legal work is figuring out how to get your client a green card. By and large in immigration law, approximately 65%, so the majority of people who get a green card get it through a family member. You might hear people talking about chain migration as a thing. This is a very, very common way within our current system for people to bring families together, reunify people who are living abroad, and it is by far the easiest and most common way for someone to obtain lawful permanent resident status. About 14-15% of people get their green card through some form of employment petition, and about the same for people who come as asylees and refugees. And then the last little bit, 5% or less, are various other humanitarian protections, a program called the Diversity Visa Program, which allows people in countries that don't frequently immigrate to the US to apply for basically a lottery to have the opportunity to apply for a green card, but that's a very, very small percentage of the overall diaspora. And then because it's the most common way by far for people to get a green card, I want to talk a little bit about the family petition process. The first step for this, it's generally a two-step process. The first step is always going to be the person who is petitioning for that relative, the lawful permanent resident or US citizen family member, the person who already has status, will file a petition for their relative. Usually that has to be approved and adjudicated before the individual can apply for status. Not always, but usually. And so if that petition gets filed and approved, then it's the opportunity for the immigrant to apply for their green card based on the approved petition. And then the question will be, are they eligible to apply for that status in the United States, which is something called adjustment of status, and again, that would be filed with the Department of Homeland Security, or would they have to apply abroad? So if someone did not enter the country legally or doesn't have lawful status at the moment, if they're in the United States without being admitted into the United States legally, they are not necessarily eligible, or they won't be eligible for adjustment of status. So somebody who came into the country without any papers, has lived here for a really long time, no crimes, good person, marries a US citizen, they're still kind of out of luck. There's no opportunity for them to adjust status. That person would have to apply from abroad via an embassy or consulate, and in fact, they would face penalties for the amount of time that they spent in the United States. And while people are waiting for this process, which can take a long time, we'll get to that in a little bit, they don't have any status, so they would still be at risk of being picked up, potentially detained, placed in deportation proceedings. And then the question is what kinds of relatives can file a petition for whom? There are a couple of categories. The first one is the immediate relative category. And so for these people who are immediate relatives, there's no wait list for filing a petition. So if I, as a US citizen, was to file a petition for my spouse, that's an immediate relative, or for my child, that would be an immediate relative. There would be no wait list. However, if I had a green card and I filed a petition for my spouse, there would be a wait list. So we will look at this really quickly to get a sense of what the wait list is. And can everyone read that chart okay? It's kind of small. So basically this is, every month the Department of State will publish a visa bulletin. And basically this chart will give a rundown of how long the wait list is for different types of petitions. So basically the categories in the chart are set up like this. So F1 are for people who are the unmarried sons and daughters of US citizens. And so in immigration law, there's going to be a change or a difference between a child who is under 21 and a son or daughter who would be someone over 21. So if you have a child over the age of 21 that you want to file a petition for, they would be in that F1 category. And so it can be kind of hard to read, so I'll just kind of tell you. So in that top column for F1, if you were filing a petition for a non-citizen who lived in any country in the world other than the 4 that are listed there, China, India, Mexico, or the Philippines, then your waitlist date would be August 2012. So that's about 7.5 years that someone would be waiting to bring their unmarried son or daughter to the United States. However, for some countries, like if you look in Mexico, the wait list is all the way back to October of 1999. So yes, so they're currently approving petitions that were filed in 1999. So you could basically draw, so if I was to file a petition now, based on this information, I would anticipate that it would take 21 years for my son or daughter to finally get approved to be eligible to apply for a green card if they were a Mexican citizen. Adult son or daughter. If it was a minor, if it was a child or a son or daughter under the age of 21, it would be an immediate relative, and that would be different. So that's a good point to clarify.
But all other countries then are not waitlisted if you are unmarried sons and daughters of U.S. citizens?
So that's just for the Mexico column. So for all countries other than China, India, Mexico, or the Philippines, it would fall under this all chargeability areas except for those listed. So the second column over. I know the chart's kind of confusing, especially when it's hard to read. But so basically there is a wait list. So for a son or daughter over 21, this says it's August 22nd, 2012. So that's what I was saying it would be. So see, the child was Guatemalan and not Mexican. It would fall under that category. So instead of having to wait 21 years, we're talking about 7.5 years. But still, for reuniting with a family member, 7.5 years is a long time. No, that's after the petition is filed. The applicant would have to wait that long after the petition is filed to be eligible to apply for the green card. Does that make sense? Okay. But during that time, we're talking also about, these unmarried sons and daughters have to remain unmarried sons and daughters to qualify. If they do not, if they get married in that 7.5 years, then they would change to the F3 category here and become a married son or daughter. And so just a simple act of getting married would drop that person's wait time from August of 2012 to June of 2007. So basically it would add another extra 5 years to their wait time just by getting married, which again, over a period of 7 years is a long time to not make life choices. Sir?
Are these wait times, these delays, a matter of regulation or just a matter of circumstance due to staffing?
Limited visa availability. So there's only a certain number of visas per country that are released on a year-to-year basis. It's a very small number of visas, and because of that, it creates a significant backlog. And as you can see, and I'm more than happy to share these slides if anyone would like, we can email them out and you can look at this a little closer, or you could just go on Google and type in visa bulletin and this chart will pop right up. And you can study it a little bit and get a sense of how long some of these things will take. But because of long backlogs, like there's a lot of people who are trying to petition for family members in Mexico right now, and that's created a really long backlog where those people are waiting since 1999. I'm just looking at the chart right now to see if there's any other really bad ones. So for the F4 category, if you're filing a petition for your sibling, if you become a U.S. citizen and your brother is still back in Mexico or the Philippines, that petition would have had to have been filed in 1998 to bring them here. Whereas if we're talking about, again, you want to petition your brother from Guatemala, you're only waiting since 2006, so significantly shorter.
There was a thing that when we put the ban on people coming, we said that some of them would have to reapply, that they had gone
we'll keep going with the presentation, and we'll get into some of the more recent changes in immigration law since the new administration, so we will get to that point.
One quick question. So when you say that there's no wait list, I understand that there is no such a thing as a quota per se, but how long is the process between the time that you file for the spouse or children and until you get a response right now?
So when you file the petition, so there's the two different things. You file the petition, probably takes, I mean, truthfully, doing detained work, I haven't filed a petition like this in quite a while. My understanding is it's taken about 7 or 8 months. You get an answer on that petition. But basically, from the date that that petition is initially filed, you are assigned what's called a priority date. And that priority date that comes on your receipt after you file the I-130 petition, which would be the petition for the relative, that is the date that basically gets locked in for this chart. So you know your priority date is going to be like, if you file a petition today, your priority date would be January 28th, 2020, and then you would sit in this chart, and in 2046, maybe it's time to bring your brother from the Philippines or something like that, depending on how the chart evolves month after month. Okay, does that make sense? Okay.
So the relationships that are listed there are the only ones that are considered immediate family, so
Yes.
grandparents, aunts, uncles, and so forth?
Yeah, exactly. Grandparents, aunts, uncles. If you're a lawful permanent resident, your siblings you can't file petitions for. Only citizens can file petitions for siblings. These are the only people. So sons and daughters of U.S. citizens, spouses and children of permanent residents, unmarried sons and daughters of permanent residents. So married sons and daughters of permanent residents are ineligible. So if you have a green card, you either need to file for citizenship to be able to file a petition for a married son or daughter, or they would need to think about getting legally divorced potentially in order to be able to come here. And then married sons and daughters of U.S. citizens and siblings.
If the petitioner is not a U.S. citizen, are they allowed to leave the U.S. to visit their homeland?
You can only be a petitioner if you're a permanent resident or a U.S. citizen, and either of those classes of individuals would have the ability to file such petitions. All right.
Is it respected the same way whether they're the LPR or a citizen?
I'm not sure if I understand. I'm sorry.
If I ask to have my children come and I'm an LPR, is my petition as strong as if I were a citizen?
They would both be adjudicated in the same way. The only questions would be what class you would fall into. So it's just a matter of the categories of processing. And then we'll keep going, and just because we have a lot of information to cover on this, we'll try and hustle through and maybe limit questions till the end, if that's all right. So getting back to this, the key point for applying for a green card in terms of adjustment of status is if the individual is in the United States, they have to be eligible to adjust status. So filing the petition isn't enough on its own. You also need to prove that you were lawfully admitted into the United States. So if you are not lawfully admitted, if you cross the border without permission, generally you're not eligible to adjust status in the U.S., no matter if you have a U.S. citizen spouse, U.S. citizen brother with a current priority date, anything like that. There are some exceptions, and I'm not really going to get into them today just for the sake of time, but generally it's impossible for people who enter the U.S. without papers to pursue adjustment of status here in the United States. So in those circumstances, that individual who is the beneficiary of the petition can leave the United States, but there are certain risks that because of the time they've spent illegally in the U.S., they could face a bar from returning. And this is, I think, where we get to like one of the very common things that people talk about in immigration law, going to the back of the line, waiting your turn. But for many people, the sheer truth of how immigration law works right now is that there's not a line for people to get in the back of. For many undocumented individuals, leaving the U.S. will make it difficult or actually impossible for them to legalize their status. And the reason for that is that there are bars for admission if you have spent time in the U.S. without lawful status. So if anyone has been in the U.S. for more than 180 days, but less than 1 year, then they leave. They would face a 3-year bar in which during those 3 years they would have to remain outside of the United States and could not apply for readmission. If they've been out more than 1 year, it's a 10-year bar. If an individual is deported from the US and then returns without permission, there's a permanent bar. So if an individual is previously deported, then comes back without papers, marries a US citizen, it doesn't really matter how awful and tragic and sad the situation is, you know, like mom has cancer, kids are sick, whatever. It's a permanent bar where there's really very, very little ways to get around that. Waivers are available, but increasingly they are getting harder and harder for people to obtain, and you have to show an extreme hardship to the family to even be considered for such a waiver. And this is continually an area in which immigration law is getting more and more challenging, and there's more and more restrictions for people trying to do this. So there's not a line or an easy way for people to pursue lawful status, unfortunately. So we have a little flow chart here. This is kind of what we were just talking about earlier. So if you're eligible for a petition, you can file, get on the wait list. If you're in the United States, you go to the top, figure out if you're eligible to adjust. If so, then you can file an application, interview in the US, and get your green card. If you're not eligible, you can either file a waiver or leave the country and process at a US consulate. And then there you would go to an interview with the Department of State and pursue your case that way. If you're approved at the Department of State, then at the consulate they would give you a stamp in your passport. You could come to the United States and enter with that stamp, and then you would get a green card mailed to you once you were here. So that was family-based adjustment. I know that's a lot of information. It's really complicated, but I think it was important to spend a little bit of time on that because it is such a significant part of the US immigration system. This stuff I think we'll speed through a little bit because it's really complicated, and truthfully neither Jesse or I have done a ton of employment-based stuff, so I don't know how qualified I am to talk about it except for very general terms. But in practical terms, getting your green card through employment is really not available for many people. We're really just talking about people with really specialized, extraordinary abilities, people who are able to fill jobs and positions in the US that there are no qualified people to fill in the US. So we're not talking about, you know, like there's no one who wants to go pick tomatoes because it's too hot in Alabama, and people who are willing to do the work that people don't want to do. We're talking about people who have advanced degrees and skills that are necessary for our economy or desirable for our economy in a way that they couldn't be theoretically replaced by US workers. So you're talking about investors, people of extraordinary abilities. Generally, this is something very common in the tech sector and things like that, with people who are able to add significant value to major corporations. But as a practical matter, if you fall out of status, like we were talking about those bars, if you're ever out of status for more than 180 days at any point, you're basically going to be ineligible to pursue an employment-based green card. So falling out of status for even a pretty short period of time, like you're here on a student visa and then you graduate in May and you don't really have anything going on and your visa expires, and then you get an opportunity for a job, but you know, you spent those 6 months unemployed without a visa, and really there's not an option at that point for you because of the restrictions on employment-based visas. There are some other avenues for green cards, and I think we'll review these a little bit just to make sure that you understand them, because they definitely will come up, especially if you're working with people at the detention center. The purpose of this training is not to cover all of these, so we just want you to be familiar with what they are, and then we'll go into more detail about asylum in the next session. But one of the most common ones that we run into are people who are applying for protection based on fear of persecution in their home country, which would be applying for either asylum or refugee status. And does anybody know what the difference between those two terms is? Yes.
Asylum is someone who crossed our border and asked for asylum, and a refugee is in their own country and they go to the embassy and get permission there. The problem with being a refugee is that it's too dangerous for you to stay in your country while you wait for them, so you leave and become an asylum.
Exactly. So refugees are admitted and have permanent status before they even enter the country. It's processed by the Department of State. Asylum cases are either processed by the Department of Homeland Security or the Department of Justice. So either in immigration court, which is what we see at the detention center frequently, or you can file an affirmative application if you are not detained. But the main difference is asylees are here in the US on our soil, refugee seekers are abroad. And then the next category is people who are seeking benefits under the U visa or T visa program. Are people familiar with those? So who qualifies for a U visa? Anybody? Deborah? Victims of certain crimes. So if you're the victim of a certain violent crime and you are helpful and cooperative to law enforcement, you can file for a special petition. Does anyone know what a T visa is for? Paula, you know. Oh, I'm sorry. Okay, so T visas are for people who are victims of human trafficking. So either sex trafficking or labor trafficking. The next one is cancellation of removal. So for certain people who are placed in deportation proceedings, either lawful permanent residents who have had an adverse interaction with the criminal justice system and are now deportable, or people who have lived in the US for 10 years or longer and have US citizen relatives who would suffer hardship if they were removed. People in either of those classes can seek a relief form called cancellation of removal in front of the immigration judge. It can only be granted one time, but cancellation is a way to allow someone who has exceptional circumstances to basically get a second chance. And this is definitely one of the main areas of pro bono cases that we refer out. So as any attorneys who are in the room who are interested in taking pro bono cases, there's a very good chance that we might discuss cancellation of removal cases at some point. Another is protections under the Violence Against Women's Act. So people who have been victims of domestic violence, even though it's called the Violence Against Women's Act, any victim of domestic violence, whether it's a same-sex couple or heterosexual couple, male victim of domestic violence, female victim, it does not really matter. Anyone can qualify under this, but it's protections for people who have suffered domestic violence, generally against an abuser who is a US citizen. Special immigrant juvenile status is for juveniles who would have faced abuse, abandonment, or neglect, and it would not be in their best interest by judicial order for them to be returned to their home countries. And then there's a few other special things like the Cuban Adjustment Act, which, as you can guess, is for Cubans, people who have served in the US military, and the diversity visa, which is the lottery system I talked about earlier. And then another thing to talk about is if you have your green card, citizenship is a question that a lot of people have, and what's the difference? I think sometimes people think, I have a green card, I'm a citizen. What is the difference, and how does that process happen? So the main difference between green card holders or permanent residents and citizens are that citizens are afforded more rights. The other main difference is that once you have naturalized as a US citizen, you cannot get deported. Whereas permanent residents, if you're convicted of certain crimes, can still be placed in deportation proceedings. So permanent residence is not necessarily permanent. Generally, if you choose to naturalize, you are eligible after being a permanent resident for 5 years. However, if you're married to a US citizen for 3 years in that time, you can kind of move ahead a little bit and expedite that process. There are several other requirements for naturalization, and one thing that's very important before you ever talk about naturalization with a client is to make sure that you review any criminal convictions they might have and understand that the naturalization process can be risky because an application can be denied. And if you do have a conviction for a deportable offense, filing a citizenship application to naturalize could potentially trigger deportation proceedings against you. We've unfortunately seen that more often than I would like to. And now we'll kind of get into the less affirmative things and talk more about what happens in removal or deportation proceedings. And also we're going to cover immigration detention as a part of this. How are we on time? Okay. So basically, the process to determine if an individual is going to be deported from the United States comes down to two key questions. The first is there a reason that this individual is removable? Either they're here without papers, they have committed a crime that renders them deportable. There has to be some formal charge against that person. And so those charges are all listed in the Immigration and Nationality Act under the grounds of inadmissibility and the grounds of deportability. So we can discuss that as you move forward in the case and make sure that you understand what charges are levied against your client. We're not going to get into that here today. And then the question is, once you decide if your client is indeed removable, is there a defense to deportation? And that could be applying for asylum, cancellation of removal, a family visa petition, or anything of that nature. If you do take a case with NWIRP, we will generally have identified what eligibility options exist for your client and be able to discuss that with you at the point you would take a case. So that step, you're not going to have to worry about doing that analysis. We'll do that and then review that with you. And then basically, there's a lot of ways that people wind up in the removal process. One of the very most common is interactions with the criminal justice system. So ICE is around jails and keeps an eye on court dockets and everything. And if someone has contact with a jail, they're convicted, plead guilty to an offense that renders them deportable, it's very likely that ICE will place a hold on that person or view them as a person of interest and detain them shortly thereafter. Also, there are a lot of people who come on the radar of ICE after committing some minor infraction that doesn't make them deportable, but they don't have any lawful status. And that just kind of flags that person to ICE's attention. So a lot of times we see people who get picked up as they're leaving court for minor things, for more significant things. Another thing that can happen is if you file an application and it gets denied. So like we were talking about, if you apply for citizenship and you have a crime that makes you deportable, you kind of are introducing yourself to ICE on the radar that way, and you can be detained and placed in removal proceedings. In addition, a very common thing is interactions with ICE and Border Patrol and other avenues. Generally, people get arrested near borders. Crossing borders is a very common thing. And even sometimes we see people who are not deportable, who are lawful permanent residents or U.S. citizens who have legal status and should not be considered deportable, get caught in this system and wind up at the detention center. It happens not extremely frequently, but we definitely see cases of citizens getting detained incorrectly, through racial profiling or whatever it might be, and definitely times where there is a very valid argument that the conviction that they have is not a deportable offense. And once you're placed in removal proceedings, really it's up to ICE's discretion to determine whether they will detain you or not detain you and give you a court date. And that kind of affects how your case moves forward. If there are two courts in the Pacific Northwest, in Washington State rather, there is a court in Seattle, and they handle non-detained cases, and there is another court in Tacoma at the detention center, and those handle all of the detained cases. So basically, if you're placed in removal proceedings by ICE, if they detain you, your case will be transferred to the Tacoma court. If they opt not to detain you, your case will be with the Seattle court. And a very, very important thing to underscore, that even though these are trial proceedings and people can be placed in jail during the entire course of it, there is no right to appointed counsel in immigration proceedings. If the person cannot afford to hire an attorney and a volunteer attorney is unwilling to take the case, the person has no right to an attorney. And I'm not sure how up to date these stats are, but the last that I was aware, approximately, 1 in 3 removal cases in Seattle were unrepresented. So 33% of people did not have lawyers at the Seattle Immigration Court, and that number grows up to 86% of detained cases. People are unrepresented in their proceedings. Again, that just underscores the huge need that we have to have more volunteers working in our courts. Here is a picture of the Tacoma Immigration Court, if any of you have been there. And then the court is in the same building, which is the Northwest Detention Center. We're going to talk about this a little bit more in the future presentation, but just to kind of review real quickly, it's located in the Port of Tacoma, down in the Todd Flats. Since 2009, it's been expanded, and now there's 1,575 beds in the facility. And there's several government agencies that work there on site. There's the Executive Office of Immigration Review, which is the Immigration Court, and that's the Department of Justice like we were talking about. And then in the Department of Homeland Security, we have ICE. So there are deportation officers who are the people who do more of the enforcement and oversee the arrest and detention of the people at the detention center. And then there are the ICE trial attorneys, or the Office of Chief Counsel, and they effectively work as the prosecutors in the case. If you take a detained case, you would have an opposing counsel, an attorney who's prosecuting the case and trying to deport your client. Yeah.
A technicality here, they renamed the center, as you know, it's now called the Northwest ICE Processing Center.
Yeah, no.
Dated now.
It is a little dated, but also their website still calls it the Northwest Detention Center. So I'm not.
So that we know moving forward, it's has been renamed.
Exactly. Thank you.
When was the facility built?
I believe it was 2004, Jesse. Yeah, 2003, 2004, something like that. But I'm not positive.
2004 for 1,000 people.
Yes, and then it was expanded in 2009, but I'm not positive about that date. And then basically an overview of what types of populations of people are at the detention center. One of the very common groups is, that seems a little counterintuitive, we picture it's people in our community, which it is, but also this is the third largest detention center in the country. And because of that, a large amount of asylum seekers who arrive at the southern border and request asylum there get transferred up here because of the bed space and the access to the court. So we do see many people who come up from the southern border who have never been to Washington. A lot of them are confused and they think that they're on the East Coast in Washington, D.C. They have no idea where Tacoma is on a map. And then we also see lawful permanent residents and visa holders from here in the community who have been convicted of certain crimes that make them deportable, people who are undocumented in the community, people who have overstayed their visas. And then, for me, I think one of the really heartbreaking populations that we see there are people who came as unaccompanied youth who entered without any papers, without parents, and were placed in the foster care system until they turned 18, and then they age out of foster care and they wind up being detained. So there are a fairly large population of very young people at the detention center, but the detention center is 18 and up. There are no children there, although it doesn't feel that way when you're talking to someone who just turned 18. And then the population is about 88% male from a wide range of countries, but the vast majority of folks are from the Northern Triangle in Central America and from Mexico. Length of detention can vary on the case. I think that 2 weeks is probably the shortest that someone who had a previous order of deportation is likely to stay at the detention center. This says 2 weeks to 4 years, but frankly, I can think of at least a half dozen people who have been there for 7 years or more. So, it depends on the case and what type of relief or what type of court case that person is fighting. And then to talk about ourselves, the Northwest Immigrant Rights Project, and what we do at the detention center. One of the main services we provide is LOP, which is our Legal Orientation Program. We provide legal services for people who don't have attorneys so that they at least have a chance to talk to someone who is an expert in immigration law and understand what their options and rights are. We do that by providing group presentations as well as one-on-one intakes. And then we do pro se workshops. So basically, prior to someone having their individual hearing, where they'll be going by themselves to go to court and try to present their case as best as they can, we have a workshop where we'll sit down with people who have similar cases, and an attorney will kind of coach them, answer questions, and help them to prepare for what to expect when they go into court by themselves. The other thing that we do is direct representation. So we have 2 different teams of staff attorneys and legal advocates in our Tacoma office who are focused on providing direct representation to vulnerable populations in detention. Jesse has been part of both of those teams. And then we also work with pro bonos, recruiting and training them to provide additional representation on top of what we're able to provide in-house. And that is my role at the organization. Yeah.
How do you choose who you represent?
Some of it is restricted by what grants we have. So we do have a grant that is through King County that basically allows us to represent people who reside in King County. So if you had resided in King County at the time you were detained, there's a much better chance that we will be able to represent you because of the funding that we have dog-eared through that grant. But we do have other less restrictive funding where we focus on taking cases where we feel an attorney will do them most good. So not in a case where we think we will be able to win if we take it necessarily. We take cases knowing that there's a good chance that we might lose sometimes, but the cases that are the fights that need fighting the most, and where we think that a person almost certainly would not win on their own, but we might be able to help get it to a point where they have a fair chance. And that's, in a way, what we also look for with our pro bono program. We're trying to put people in positions where they can help people get the case to a place where it needs to be so that the person has a chance to be successful. With our pro bono program, we try to isolate cases that have more straightforward legal facts so that someone who might not be an expert in immigration law right at the beginning doesn't have to learn everything, that it's more straightforward, not necessarily easier or more likely to win, but the facts are fairly straightforward, so yes. So basically, to go over this really, really quickly, because we will go into this more in great detail when Jesse speaks in a little bit, but asylum is one of the main forms of relief that we see at the detention center. And asylum is a protection for individuals who fear persecution based on their race, their religion, their nationality, their political opinion, or being a member in a particular social group. So that's a really important thing, is that those categories are the qualifications under the law for asylum. General civil strife, economic hardship, a neighbor who, like you're scared of, anything like that is not necessarily going to be sufficient to get you to the level of asylum, even if it's really bad. You also need to be able to show that the government cannot or will not protect you, and that you couldn't relocate internally to avoid harm. So if you were having issues in Michoacan in Mexico, but you could very easily move anywhere else in Mexico and be fine, it's possible that you would lose your asylum case based on that fact. There are a couple of other forms of relief that exist in addition to asylum that are very similar. One of them is called withholding of removal, and one of them is called Convention Against Torture. And basically, either of these forms of relief are for people who, for some reason, are not eligible for asylum. For example, they applied after they'd lived in the US for a year or more, or what we're seeing right now, there was a lot in the news about an asylum ban that was passed this past July by President Trump, and effectively saying that people who entered the US after passing through different countries on their way without seeking asylum in those countries are now banned from asylum. So more often we are seeing people who are not eligible for asylum in the immigration court because they entered the country after July 16th. They still are eligible for withholding of removal. The challenge is that the standard there is greater. You have to show that you're more likely than not to be persecuted in order to win withholding, whereas for asylum, you just need to show a probability. So the rule of thumb that we kind of go by is to win an asylum case, you need to show that there's at least a 10% chance of persecution. And with withholding, you have to show 50% or more to give you an idea. So the bar has been significantly raised, and it's getting much harder to win an asylum case. Again, another reason why it's very helpful to have attorneys to help organize cases and present them in clear, coherent manners so that the judge can understand what relief this client is eligible for. The other very common form of relief we see in detention is cancellation of removal, which can be for people who are lawful permanent residents or for people who have lived in the US for 10 years. Basically, to qualify as a lawful permanent resident, you need to have had your green card for at least 5 years and continually lived in the US for 7 or more years after your initial admission. Also, there are certain crimes that are called aggravated felonies that are disqualifying. And then you can't be eligible for cancellation if you got it previously. So if you've won a cancellation of removal case 2 years ago, you can never apply for it again. And then the main thing that you have to do with a cancellation case is convince the judge to grant on their discretion. The eligibility component of it's pretty easy to establish. You just show 5 years, 7 years, and no serious convictions. But then you have to convince the judge that there's enough compelling evidence that this does merit a grant and approval. For non-permanent residents, it's a little harder. You need to show that that person has continuously lived in the US for 10 years, and for people who are undocumented, that can be tricky sometimes. They don't necessarily have a clear-cut paper trail. They don't have the green card or whatever it is. Like, you don't get a certificate showing you entered the US without papers on this date. So showing that you've continually lived for that time can be challenging, and you have to convince the judge of that. But then the other challenge is that you have to prove that your removal would cause exceptional and extremely unusual hardship to a US citizen or LPR spouse, parent, or child. So you can't really word it more strongly than exceptional and extremely unusual. So basically the bar is fairly high to convince judges to allow people who have lived here undocumented for an extended period of time this chance. But if you can show that hardship and that you have good moral character and you have not been convicted of certain crimes that would render you ineligible, then you can be granted, again, based on the judge's discretion. So these cases are really hard to win, but they can make a huge difference, and they can help someone who has been here for a long time without any status get a green card. So they're definitely worth fighting when we can. There's also the Violence Against Women's Act, which we talked about briefly before. This is protection for spouses and children of abusive citizens and lawful permanent residents. In order to qualify, you need to be married or divorced from your partner within the last 2 years. You need to show that the abuser was either a US citizen or an LPR. But it doesn't require that you called the police, but this can be a path for a green card. And then we talked about this briefly before, but U visas are protections for victims of certain crimes, including domestic violence. So this could be an alternative way for someone who maybe has been out of their abusive relationship for more than 2 years to seek relief. You need to, in these cases, show that you suffered substantial abuse and been helpful or willing to be helpful with the police investigation or prosecution of an offense. So unlike VAWA, you do need to show some contact with law enforcement and get law enforcement to sign off on a certification saying that you were helpful.
You say subject to cap on the
Yes.
two of those?
Mm-hmm.
What does that mean?
So there's a cap on how many visas get released every year. So with U visas in particular, the cap's 10,000.
10,000, and right now the backlog is, they have 130,000.
Yeah,
So
so
you're looking at 13 years before you would actually be granted a visa. One thing, just quickly with that though, is that even if someone applies though, they would be put into deferred action before that, so they would have the ability to work lawfully. So it's still worth it.
mm-hmm. Yeah, so if anyone didn't hear Jesse, basically there's a cap of 10,000 a year. Right now, the wait list is probably about 13 years or so for a U visa to come current, but in that interim period, you can apply for deferred action, so you can get a work permit and kind of get on with your life in that interim time while you're waiting. But still, 13 years is a very, very long time to be waiting for status. T visas for victims of human trafficking, you have to basically be able to prove that you are either a victim of sex trafficking in which commercial sex acts were induced by force, fraud, or coercion, or the person is under 18. So if you were forced into sexual activity under the age of 18, that is also possibly grounds for a T visa. And then the other option is labor trafficking for qualifying for a T visa. And in that, you would have to show that you were involved as a victim of the recruitment, harboring, transportation of a person for labor or services, again, through the use of force, fraud, or coercion. So this can be a lot of different things. It can be forcing someone to work for their business and then cheating them out of pay. It can be forcing someone to traffic something across the border, forced domestic labor, things of that nature. And then another important thing to talk about, even though this doesn't come up as much in the detained setting, because again, we're talking about people who are 18 and up, is special immigrant juvenile status. This is a protection that's available to youth who cannot be reunified with one or both of their parents due to abuse, past abuse, abandonment, or neglect. The thing that's tricky with these cases and what's important about them is that you need to get an order from a state court, so it's not entirely an immigration proceeding. You need to find a court, go to court, and have a judicial order showing that the youth is dependent on the court, a dependency finding, and that it's not in the youth's best interest to return to his or her home country. The thing that's tricky about these cases is that generally dependency hearings are for children 18 and younger, but the immigration statute for SIJS is for children with a definition of child being up to 21. So something very exciting that happened a couple of years ago is that Washington passed a special bill creating something called the Vulnerable Youth Guardianship, which is a law that exists in Washington state and allows state courts to issue dependency orders for young people between the ages of 18 and 21. So even if you would have otherwise aged out of dependency hearings or foster care or any of those other things, you still could potentially pursue this form of relief so long as you're under the age of 21. Another benefit, and this is one that we'll kind of gloss over, it's in the news a lot lately, is temporary protected status. There are several different countries. They're listed here in kind of small print. El Salvador, Haiti, Honduras, Nicaragua, Somalia, Sudan, South Sudan, Syria, Nepal, Yemen, that have have been beneficiaries of this program for temporary protected status, where some act of God or other major disruption has made it so that it's unsafe for people to return to their home countries, and there can be a temporary renewable status that allows people to live in the United States, have work authorization, and continue to renew that status. The problem that's tricky with TPS is that it is not a permanent status. It could be rescinded. You may be ineligible to file again if you are not timely in refiling, every 2 years. And then the other challenge is that, it's eventually going away, and the current administration is trying its best to wrap up TPS for individuals in several of these countries. Speaking of things that are at risk of going away, the Deferred Action for Childhood Arrivals, or DACA program, which was created in 2012 by President Obama. I mean, are most people familiar with DACA and what it is? So basically, it's not a path to permanent residency or citizenship, but for kids who came here as young children, they can apply to get a 2-year work permit and social security number through the DACA program. In September of 2017, President Trump announced that he was going to wind down and eventually terminate the DACA program. That was blocked by different federal courts, and so at this point, people who were DACA recipients can continue to renew that status for the time being, but no one who is not already a DACA recipient can file a new application at this time. So no new applications, but you're safe if you already have DACA for the time being. However, in this session with the Supreme Court that's going on right now, it's very likely that this case will be heard. So this is news that will be upcoming, and it's very likely that sometime in the next 6 months, there will be a major decision on the legality of DACA and the ability of the president to terminate the program. So we honestly have no idea how that will play out, and we'll have to wait and see. And that's a good segue to other developments with what's happening in immigration currently under this administration. One of the good things is that a lot of forms of immigration protection are written into law, so a president can't unilaterally change them. And that is something that, was somewhat unhelpful, with the creation of the DACA program. There were certain limitations for President Obama that he was not able to make it as broad a reach as he would like. People had talked about the DREAM Act and something that would allow a path to permanent residency and citizenship to Dreamers, and that really wasn't viable without Congress getting involved to make a new law. So the limits and the powers of the president are somewhat limited, whether that's beneficial to immigrants or whether it's harmful to immigrants. So a president alone couldn't cancel U visas or asylum, just as a matter of course. However, there are several ways that government authority and the executive branch can chip away at these protections, even if they are not going to outright abolish them, because they cannot do that. One of the big ways is through case law. So the Attorney General's office can issue really negative, harmful decisions that make it harder to argue cases. We can reduce the number of refugees that are allowed into the country. In 2019, the ceiling for refugee admissions was reduced to 30,000 individuals, which is the lowest it's been in my lifetime. And actual admissions were only 22,000, which is the lowest ever. There are other programs such as TPS and the Central American Minors Program that the Trump administration has tried to terminate, but those are facing challenges in court. And then another thing is just higher ICE activity. There's a higher risk for people. If your application is denied, you could be placed in deportation proceedings. And so really, even though there's a congressional safeguard that the president can't change the law, and that's checks and balances and how all of that works, there are a lot of little things that are chipping away at the very complex immigration machine that make these cases harder than they were 5 or 10 years ago. And I think people who are volunteers who have come back and taken cases, like a case a year or something like that, will definitely notice new laws and new changes that have happened in the past couple of years that are making cases that might have absolutely won 5 years ago be more tenuous and more challenging.
Asylum is limited too because of the new ruling that you have to ask for asylum in the first country you pass through.
Absolutely. And that is something that we'll discuss at greater length in the next presentation. And then another thing that we're noticing is changes to immigration enforcement and more ramping up of how ICE is interacting in the community. There's higher focus on people who interact with the criminal justice system. We have seen ICE just sitting in open court in different courthouses, especially in Eastern Washington, and seen them, detaining people who are even coming for dependency orders and looking for protection orders, and people who are not being charged with crimes, but who are undocumented. There's an increase in what's called fugitive operations teams. So when ICE can find information about someone who they expect is in the country unlawfully, that person is considered a fugitive, and they will send, a squad of ICE agents to knock on someone's door. I had a client who was an African-American man from the Caribbean who was undocumented. And he got a knock on the door at 6 a.m. His wife opened the door. They showed a picture of a Hispanic man with a bunch of face tattoos and everything, and said that they had information that a dangerous gang member was living at that address. She said it was ridiculous. They asked for permission to come in and just confirm that that person wasn't in the house. And then immediately once they were in the house, they identified my client by name and put handcuffs on him and took him to the detention center. So fugitive operations are definitely increasing. It can be deceptive. It's challenging for people if they don't know their rights. Again, the purpose of this presentation was not a Know Your Rights presentation, but we do those on a regular basis and encourage members of the community to understand so they can be allies to people and understand what those rights are. But very shortly, unless there is a warrant that's signed by a court, you do not have to let an ICE officer into your house. And there's a big impact that this has on communities, obviously. There's fear. If you're the victim of a crime, do you want to go to the police, or do you want to go to court to try and get a protection order if you know that ICE might be there and they might ask you questions? How do you feel? Do you feel safe doing that? Are you willing to get these protections that you or I would assume as a matter of course the right thing to do? And then another challenge is a fear of accessing public benefits and help and medical services that should be available to everybody in this country. And I'm not sure if anyone saw any of the news from yesterday, but there was a Supreme Court decision that came down that was pretty negative. And so the Immigration and Nationality Act, like the overarching immigration law, has always had language in it saying that people who are deemed to be a public charge are not eligible for immigration relief, that they can be denied admission into the US initially, or they can be denied an application for a green card. But public charge, what does it mean? It's a very vague term, and there's no clear definition. So the executive branch kind of has offered guidance on defining what it means. At different times in our history, it's been used pretty negatively. The public charge ground was one of the main things that was used to deny admission of Jewish refugee seekers leaving Nazi Germany. And now we're seeing it being something that has been broadened to expand the definition of what immigrants who are trying to apply for lawful status could be considered public charges. The proposed expansion of this includes, one of the main changes is that if a family member of yours seeks public benefits, so if I am an undocumented person and a parent, but my children were born here and are citizens, it used to be something where my children who are US citizens can get benefits because they're citizens and they're entitled to them. But now the government could look at the fact that I received benefits on behalf of my children and use that to determine that I'm a public charge, so that even if my partner filed a petition for me and I was eligible to adjust, I could be denied because of the choice I made to get food stamps for my child or something of that nature. So really it impacts disproportionately low-income individuals.
Just an added comment, I'm working on a census program, and that's one of the things that they are very concerned about, is that we will get such an undercount of any kind of immigrant in this country because of the fear that ICE will, as soon as you fill out a census form, that ICE will be in.
Yeah. And just as, just taking a quick visual poll of the room, a lot of us are Caucasian folk, and one thing that we'll talk about in the third presentation about working with people in these proceedings is, when consistently there's a fear of, what people might do to screw you over, why should your client trust you? Why are you the one person who they should believe and they should trust? And being mindful of that and respectful, and not assuming that you'll just be the savior who swoops in to take the case and your client's going to love you right away, because you might have to earn their trust, and that's fair. And then we'll touch briefly on this, and then we'll try and do a couple of questions quick before break. But basically, sanctuary policies, the one thing I want to say about this is that cities can make decisions to be sanctuary cities or have those policies that they are not going to explicitly cooperate with ICE. That doesn't mean that ICE can't go to those places and detain people on their own information and their own efforts. So if Seattle's a sanctuary city and you live in Seattle, that doesn't mean that you can't get detained by ICE in Seattle. That means that if you go to the police in Seattle, they won't be calling ICE 5 minutes after you leave to let them know that you're there. But even then, there's no guarantee that information isn't getting out. So there are challenges with that, but we are out of time right now. So I'll really quickly do a few questions and then we'll take a break. I believe it is, but I actually don't truthfully know. Yeah.
The cancellation of removal, does it allow eventually for any kind of adjustment to the LPR?
No, that's an excellent question. I think I breezed through that a little too fast. So if you're granted cancellation of removal, so if you're a lawful permanent resident applying for cancellation of removal because of a conviction, if you're granted, you keep your lawful permanent resident status, but also you keep it from the date that you initially obtained it. So if you do want to apply for citizenship in the future and you consult with an attorney and they believe that because of your convictions it's not a risk for you to apply for naturalization, then you can go forward and do that once you have your 5 or 3 years, which you should already have theoretically if you're eligible for cancellation. And then if you're applying for 10-year cancellation, so you're undocumented, you've been here for 10 years, at the time that you're granted, you are eligible for a green card. So you will get a green card. But again, there is a cap on that, so there's only a certain number of visas that will be released on any given year. One of the exceptions to that cap is if you're granted 10-year cancellation in detention, then you can get a green card whether it doesn't count against the cap. So you would be released from detention with, well, not with a green card in hand the day you leave, but you would get one in the mail shortly thereafter. You'd be a permanent resident on that day. Sam?
I don't know if this is an old wives' tale, but like if you're in a Greyhound bus in Eastern Washington, can ICE come on board and say, everybody show me your ID? Can they do that?
Yeah,
Yeah.
they do.
Absolutely.
But I mean.
I mean, no, that happens very frequently at the Spokane Greyhound station, especially.
But what if I say no?
It has to be voluntary. They can't force you to show that documentation, and you don't have to speak to that individual. So you.
However, the issue for lawful permanent residents is they actually are required by law to show ID if they are asked for it. And so it's a complicated question, right? Because, you know, and if someone's refusing to show ID and they're a person of color and they have an accent, then we get into a different territory.
Exactly. So it can definitely be challenging, but travel by bus has become pretty dangerous for people, and we've seen a lot of people. I mean, honestly, like during break, Jessie would be a great person to talk to because she has worked on a couple of cases. Yeah, two, right?
One.
Oh, just one, but yeah, but she would be a great person to chat with about that. So maybe you guys can connect during break.
You had this chart that talked about how long it took to be able to be considered a citizen. Did you create that, but there were only 3 specific countries that were cited? I would like to answer that, but I was thinking there would be a shorter time, I would think, for a person from Norway or Sweden, and yet a longer time if you were from a country like Tanzania, well, Nigeria.
Yeah. Okay. So not quite. So that, I think the chart you're talking about, the one that had all of the columns, and like if you're the F1, F2, yeah. So basically there's a cap on the number of visas that the Department of State will issue per country per year. So basically what we see is the countries that have the highest volume immigration to the US can go in surplus of those caps. And there's a different cap for each of those categories, F1, F2A, F2B. So effectively, the countries that have the most frequent and heavy volume of immigrants, China, Mexico, India, and the Philippines, those are the only 4 countries that in any of those categories exceed those caps. The volume of Norwegian or Nigerian immigrants that we see is not enough to count against the caps for that particular country. So they would all fall in that very first column of all other countries. It's really only those 4 countries where we see the excess. And if you can just go online and Google the Department of State Visa Bulletin, and you can see that chart in real time. And as you look at it, you'll see that first column, like the all other countries, for some of the categories, the date for like an LPR spouse in Mexico might be the exact same as it would be for Guatemala or whatever other country, because it's caught up. Like they aren't against the cap in that category, but they are against the cap in like 3 other categories. So that's the reason. It has nothing to do with anything discrimination-wise. I mean, there are other ways that I think you can make a lot of arguments that there is discrimination in the system, of course, but that's strictly based on volume of visa applicants. So,
Who are the folks that set the caps? Are they political appointees? Are they career federal employees? How are they chosen?
well, like the caps will be set by the different departments that head those agencies. So for that visa bulletin, it would be set by the Department of State. And then I think some caps are set through Congress, through different laws, like with the U visa law, like we were talking about that cap where it's 10,000 per year and there's a 13-year backlog for U visas. I believe that cap is like written into the law that was passed by Congress. So it varies, but different government bureaucracy, and it can be different people who set the caps in different things. But it's not just a unilateral one person type thing usually. It's agencies. one last question, then we'll take a break, and we can chat in that break too.
I work with international students here on campus, and an attorney sent us an email earlier this month saying that, I don't know if it's USCIS, has started implementing an attestation for people who want to apply for different benefits or statuses, where the applicant has to indicate whether or not they've used marijuana, and they're specifically targeting recreational use states. And then that hinders their ability to apply for benefits in the future or new status. Have you heard or seen anything about that?
I hadn't heard about that, no.
Yeah, I think it just happened this month.
Yeah, I have not
That's
heard.
something pertaining to the moral turpitude part.
I mean, yeah, that would make sense, but yeah, that's news to me. And again, like, the one limitation where I'll be very transparent on this, I mean, both Jesse and I were exclusively doing detained work. So some of the things that are, by and large, like happening in the community and like non-detained avenues, like we're not the experts at NWIRP just because it's not really falling in our caseload, but it's interesting to hear that. I wasn't aware of that. So thank you. All right, so we'll take a quick break. It's 1:20 now, and then we'll get started again at